undertook certain financial obligations to the plaintiff, and he has met all of those financial obligations. There's never been a contempt filed against the plaintiff, against my client, for alleging any type of non-payment. This modification action was filed by the plaintiff in August of 2018, and in her complaint, she is seeking at least $20,000 per month, plus other obligations. She's also asking in her complaint, before anything else was filed, at least $15,000 in attorney's fees, not knowing what work would have to be done or not done. Your Honor, it is my client's position that the plaintiff is essentially asking for some type of spousal support disguised as child support, even though the parties were never married. This is not a divorce case. Alimony is not at issue. Equitable division of property is not at issue. And my client will stipulate that his income is in excess of $30,000 per month, which is the maximum that is specifically set forth in the Georgia Support Guidelines in OCGA 19-6-15. We're here today, Your Honor, asking for a protective order protecting my client from having to disclose additional financial information after making this stipulation. Now, with regard to this stipulation that he is willing to make, his actual income is no longer relevant, because for a high income deviation, the focus shifts to the best interests of the child. Now, it's acknowledged that the child has autism and he has needs, and he is looking to take care of his child and address those needs. But his income is not relevant in determining what those needs are. The statute says the focus should be on the best interests of the child, and that's what we're here today to do. For demonstrative purposes, Your Honor, I have, if I may approach, Your Honor?
You may.
I have Defendant's Exhibit 1 as well as Defendant's Exhibit 2. And these are just sample child support worksheets that I ran this morning. Defendant's Exhibit 1 shows a John Smith, a hypothetical father with a gross monthly income of $30,000 per month. And based upon $30,000 a month, his presumptive amount of child support is $2,236. But whether he makes $30,000 a month or $100,000 a month or some other figure more than that, it doesn't affect the presumptive amount of child support. As Your Honor can see in Defendant's Exhibit 2, I increased his monthly income from $30,000 a month to $100,000 a month. And that computes the exact same amount of presumptive amount of child support. So what his monthly income is doesn't make a difference. The focus is, what does the child need? And that's what we are here asking the court to focus on. It's not on what my client makes, what his wife makes, what gifts he receives, or how he spends his money. The focus is on the needs of their child. Although this issue has not been raised in Georgia, I did cite some California cases, Your Honor, which is on point with regard to a stipulation and how the burden shifts from what the non-custodial parent makes to what the needs of the child are. And we believe that those findings can similarly be held here in Georgia. The plaintiff has filed a financial affidavit, Your Honor, and as you can see in the financial affidavit, that the expenses that she is asking for, it can be plainly seen that this is not about what's best for the child. When she is listing things such as $800 expense for the son's dry cleaning expense, when she's listing $1,000 per month for clothing for the minor child, when she's listing $2,800 for extracurricular activities for the child. But at the same time, she's also doesn't have any income of her own, but she's listing $500 a month for clothing for herself, $6,000 a year for clothing for somebody who is not working, $500 a month in vacations for someone who is not working. Again, it is the defendant's position that this is a veiled attempt to try to use his position to gain spousal support disguised as child support. And under OCGA 91126C, Your Honor does have the authority to limit discovery in this matter. Regardless, Your Honor, if you find that discovery should not be limited to that extent, where he does not have to further disclose any of his information with regard to his income, we are asking Your Honor to limit what documentation does need to be provided. Again, it's not going through how he spends his money or his business dealings. That part is not relevant for the court consideration. We are asking that if any financial information does need to be disclosed, that a protective order issue with regard to how it can be used, and that it should not be disclosed to any third parties outside of this litigation. As Your Honor is aware, the media is interested in this. My client found out about this lawsuit not by personal service initially, but through the news media being asked about it. And that is even though the style of the case only uses the first initials of the parties' names. For these reasons, Your Honor, we do believe that a protective order is important to my client, as detailed in the brief, and we're asking that a full protective order be issued.
All right, thank you. Yes, Your Honor.
Good morning, Your Honor. Happy New Year to you. Thank you. Your Honor, first of all, I believe what I hear opposing counsel saying is because his client earns in excess of $30,000 per month, that he should not have to comply with discovery at all. I found that quite interesting. What I also found interesting is that somehow opposing counsel alluded to the fact that the media is interested in the case when it has been my client for the duration of this case who has wanted to keep this case private, which is one of the reasons why she filed with initials. I'm not certain what happens in the clerk's office.
I'm not either.
Your Honor, but I want to kind of start backwards from where I was going to start to speak to that issue that was just brought up. I want to hand the court 2 emails. I just want to start off right at the jump, because when the media did find out about this case in August, my office received a call from the defendant's California attorney about the case, at which time I expressed to that attorney that my client wanted to keep this case private, that my client was willing to enter into a joint motion to seal the case, and that my client was interested in entering into a confidentiality agreement. I have that here as exhibit.
But you're mentioning a California attorney for Mr. Davis, who I believe is not Mr. Golden.
Correct. Right.
So does Mr. Golden, has he been privy to whatever these communications are?
Well, one of the communications is directly to Mr. Golden, so I'm certain that he is.
Okay.
But I just want to kind of show the case, the court, that it has been Ms. Evans who has wanted to keep the case private. That will be 2. If I may approach just for
You may.
give you these 2.
Maybe that both parties want to keep the case private. That's what it sounds like. That's what I'm hearing.
That is correct, Your Honor.
Y'all are entirely capable of reaching an agreement outside of court, as you are aware.
I am aware of that, Your Honor, and in fact, we attempted to do so. Before Mr. Golden was hired, we attempted to do it with Mr. Davis's California attorney who contacted.
I'm going to object, I mean, as far as any type of negotiations that occurred.
Yeah, that's not appropriate. And are you asking to have these admitted into evidence?
No, I asked to show you for demonstrative purposes, Your Honor, because it has been my client all along. But what you can look at, Your Honor, is Exhibit 2, where we attempted with Mr. Golden this year, on January 3rd, to not even have this hearing and enter into a confidentiality agreement, which is also what we said at the 30-day status conference.
Your Honor, I'm sorry, but this is negotiations that are not, I mean, this is just a small part of communications that
being
goes on.
offered to show that there were efforts made to cooperate.
Exactly, Your Honor.
To reach agreement. I mean, there's not a motion to compel before the court, so.
Not yet.
Okay, well, I'm not going to consider a motion that's not before me.
Of course.
So I'm not sure that it's appropriate for me to consider plaintiff's exhibits 1 and 2.
Your Honor, I was just showing that with respect to the last thing that Mr. Golden said, he wanted a confidentiality order or agreement entered into.
Yes,
that my client has been attempting to do so since August.
All right. Are you
And so
saying that you'd like some time right now to try to negotiate that?
we've tried that with him for months, Your Honor. So with respect to the fact that we believe that discovery needs to be had in this case.
All right, I'm not clear, because you're saying you want to reach terms on a protective order, but then you're here opposing the protective order motion.
No,
Okay,
we don't
so
want to reach
clarify.
terms on a protective order. We want to reach terms on the confidentiality of the documents that are produced.
Which would be what a protective order would do.
Well, they don't want to produce a single document.
Okay, all right, so you're opposed to that, understandably.
Correct.
But if things are produced, then you don't necessarily have a problem with them being under some kind of confidentiality.
We have no problem with that at all. And that's been our position all along,
Okay.
which was the point that I was making.
Okay.
But, Your Honor, this case is about a woman who's basically had to put her dreams and her life on hold to take care of these parties' son. This child is 11 years old. He has extreme autism. In fact, Your Honor, he's a runner, and he's been known to run away and also to jump out of windows. He is nonverbal. Because of that, my client has to attend school with the child. Currently, right now, my client is receiving $2,000 per month. She cannot afford to have a caretaker in the school with the child every day. She does it, and if she has some sort of appointment, another family member has to do it. Additionally, Your Honor, this child has quite a few needs. So besides the fact that my client cannot work, the child has special needs. He has a lot of allergies. He has asthma. And of course, perhaps the defendant doesn't know this since he does not exercise any parenting time whatsoever. In fact, he doesn't co-parent with my client at all. In the event that she needs something.
All right, we're just here on a motion for protective order right now, so we don't need to go into that kind of.
Okay, Your Honor. Well, with respect to the complaint for modification of child support, there's been a substantial increase in defendant's income since 2010. Of course, we have no idea about it. We can Google and see that this net worth is $15 million. We can see the videos that he posts on YouTube bragging about $1 million watch, etc., just from a couple of months ago. But what we are looking at is the best interest of this particular child. Now, as the court knows, according to Georgia law, which I think is what we need to use today, yeah, that's what's applicable. I mean, I heard a lot of information in reference to California law.
Well, I don't think he's arguing that I'm bound by it. He's just arguing that it might be persuasive.
I understand, Your Honor. Well, if we're looking at the Georgia law, as the court knows, pursuant to 19.6.15, the court is supposed to make certain that this minor child shares in the economic benefit of the income of his father as if the parties were in the same home. The code does not require that they have been married prior thereto. It's just talking about making certain that this child can have the same as if he were in the home with the defendant. Additionally, Your Honor, just looking at some of the cases that deal with